Let's take a look at military service leave. The Uniformed Services Employment and Reemployment Rights Act, known as USERRA, confers numerous rights on employees who engage in military service. Employers of any size are prohibited from discriminating against people who are members of, apply to become members of, or have obligations to serve in a uniformed military service. Often, complying with this law simply means allowing the employee in the National Guard to attend scheduled annual drill training and treating the employee as if they had not been absent. But at a time when National Guard members and reservists are regularly called upon to serve lengthy deployments to other countries, employers must be aware of USERRA's enacting requirements regarding restoration from military leave. As a general rule, employees are entitled to reemployment following up to 5 years of cumulative absence, not counting periods of required training for military service. An employee taking leave for military service must notify his employer to this effect, but is not required to await permission or to decide at what time whether reinstatement will be sought following the period of military service. Provided that an honorable discharge is received and a timely request made for reemployment, an employee returning from military service must be reemployed. Service members have to report more or less immediately following service periods of less than 31 days and within 90 days of discharge when the service period exceeds 180 days. Service members who become injured or disabled during service are given up to 2 years to return to their job. The main exceptions to reinstatement requirements are when reemployment is impossible or unreasonable, the necessary training would impose undue hardship, or prior employment was temporary. Under the escalator principle, employers must attempt to place individuals returning from military service into positions, including promotions, that they likely would have attained absent of their service. The principle applies even when managers retain significant discretion in deciding whom to promote. Employers must make reasonable efforts, such as by providing training, to permit returning service members to perform their job. If individuals are not qualified to perform the jobs that they would otherwise have attained, reinstatement to the position held prior to military service or an equivalent position must generally occur. Reemployment under USERRA also means that an employee returns with the seniority he would have had if he were continuously employed and any other benefits related to length of service. Benefits unrelated to seniority must be maintained on the same basis as for other employees receiving comparable non-military leaves of absence.